We seem to have lost the ACJ. Leona, can you check what's happening? Just Sharon? Sorry.
He's being readmitted, Justice Nklandla.
Thank you.
Sorry, colleagues, I touched something and then I went off. Okay. Okay. Are counsel in?
Counsel is in ACJ. We may proceed. Thank you.
Okay, all right.
With your leave, ACJ, can the registrar clerk call the case?
Yeah,
please?
the registrar can call the matter, please.
Good morning. I am the registrar clerk for this hearing. Acting Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of Minister of Police and others and Fidelity Security Services Pty Limited for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Okay, counsel. Mr. Shagwani, are you there?
Yes, I'm the acting Chief Justice.
Okay, please announce your appearance.
Yes, I'm for the applicant together with Mr. Musuma.
Thank you, Mr. Shagwani.
Acting Chief Justice, Justice of the Constitutional Court, it's Marius Snyman. I act for Fidelity, the respondent.
Thank you, Mr. Snyman. I've told my colleagues that both of you waived your right to not to be interrupted in the first 10 minutes, so they are aware of that. Mr. Shagwani, you can start.
The Shagwani is muted, I think.
Mr. Shagwani, please unmute yourself.
I beg the court's pardon.
Yes.
This matter involves an application for leave to appeal by the applicants against the decision of the Supreme Court of Appeal. The part of that decision which informs this application is summed up in paragraphs 21 and 22 of our heads of argument, which were prepared before my involvement in the matter by Mr. Musoma. The matter involves an issue where the respondent was supposed to renew the license for its firearms in February 2016. And in terms of Section 24 of the Act, the renewal ought to have occurred 90 days before the termination date. Now, in terms of Section 3, read with Section 28, a firearm owner or holder is prohibited from continuing to possess the firearm after termination and has to surrender it to the applicant for destruction. Now, the respondent, as we speak, remains with the firearms, but it was, on my understanding, placed on record in the last argument before the SCA that same had been returned, but the instructions from our side are that they're still there. Now, what the SCA finds is in, if I may just go to the judgment, because mainly it's the interpretation of the section 3 20 and 24 of the legislation. The SCA essentially finds that it doesn't make sense or business sense that the respondent should return the firearms because its license has been terminated, but can keep it whilst applying. So it can keep the firearms whilst applying for a new license. So we submit that that interpretation is with respect absurd in the context and wording of section 3 of the Act and 24, because the intention of the legislature there was, in our submission, clear. Namely, it provides that a person who possesses a fire, who wants to possess a firearm, must do so with a license issued to them, and that the firearm license has to be renewed before it terminates 90 days.
Mr. Shakwane,
Sorry, Marie.
excuse me for interrupting you. The respondent seems to be saying one must distinguish or differentiate between ownership and possession. Can you please address me on that point, please? Because section 3 refers to possession. No person may possess a firearm without a license.
Yes.
The argument is that if one is an owner, there should be a difference between the two. Is that a correct way of interpreting the relevant provisions?
I respectfully differ from the interpretation by the respondent. The position, as I understand it from the wording of the Act, is that it says no person may possess a firearm, that's section 3, unless he or she holds a license, permit, or authorization issued in terms of this Act for that firearm. So what my submission is on this is that, one, an owner who owns a firearm would at the same time be the person that possesses the firearm, or someone will possess it, like in the context of the respondent. Their officers will possess it in terms of their permission for the use that they ask the firearms for, security reasons. Now, it cannot be reasonably said that you can own the firearm without possessing it. It doesn't make sense. It will lead to absurdity to have an interpretation of that sort, insofar as the provisions of section 3 are concerned. The owner is the same person who had applied for the license, and it's the same license that terminates in February 2016. So it's too technical and, with respect, absurd for the respondent to seek to argue that I'm merely the owner, therefore I cannot be said to be possessing. that is my respectful submission in that regard.
Well, Mr. Shogwana, I don't know what the position is now with regard to cars, but many years ago, isn't the position that you could own a car even if you did not have a driver's license?
You could own a car even if you do not
but
have
you are
a
not
driver.
permitted to drive it.
That's the point. You cannot drive
Yes.
it.
But if you say that's the point, doesn't that support what the respondent says, that you can own the firearm without possessing it, but to possess it, there must be a license. And
But
the section that you read to us earlier on, does it not say you may not possess a firearm without a license? It doesn't say you may not own a firearm without a license.
well, that is so. That's what the section says. But on the facts of this case, what we have is that the respondent bought the firearms. Therefore, it is not only the owner, but also in possession. And two, they have been possessing the firearms until and including the date when the firearms expired, which is when they attempted to approach the court for a list of the relief that they sought in the notice of motion that we have on record. And they only abandoned those, the rest of the relief bar paragraph 5 when there was a finding against them in the High Court. And effectively when they got to the SCA, they then abandoned the rest. They remain with 5 where they say it doesn't make sense or business sense for them to have to return the firearms and only later after applying for a renewal of the license to buy new ones. So the argument is made in abstract and not pertinent to the facts that are before this court.
Well, let's look at that, because you test the correctness of a legal proposition quite correctly by really looking how it would apply in general to other situations. Let me ask you this question. Are you saying that the Act does not permit a person who has previously possessed or who has previously held a license in respect of a certain firearm to apply again for a license where the previous license has lapsed? That's your argument, is that correct?
My submission is that it does not contain such provisions.
Yes, your submission is that if I hold a license in respect of firearm A and that license expires, I may not apply for a license or the same license in respect of that firearm. Is that your argument?
That is the submission I make, relying on the wording of the Act and the decision of this court in the SA Hunters Act.
Okay, we will go to the sources or authorities you rely on, but tell me what interests of the police is served by a regime that says, even though you may need a firearm because when you held the license that expires, it means that you were granted that license because it was accepted you needed it for a lawful purpose. So the license expires today, you didn't renew it. The following day you realize it has lapsed. You are still in the same situation as you have been for the past 5 years or whatever when you held the license. You still need the license, the firearm. It's just the license that has lapsed. You still qualify. During these 5 years, you have complied with all the conditions of the license. You have complied with all the law. Why should you not be able to apply for a license so that you can still satisfy the need that has previously been recognized by the police as appropriate and deserving of a license? So what interest of the police is protected or advanced by an argument that says such a person who has been loyal and made sure that he complied with all the conditions of the license throughout this period, but somehow failed to renew it, and let's assume for argument's sake that there was a valid reason for failing, there was an understandable reason for failing. What is the interest of the police that is advanced by not allowing that person to apply for a license so that they can continue to use the firearm?
Acting Chief Justice, the functions of the police in this respect is regulated in terms of the legislation. Now, the legislation constitutes a law. The firearm possessor or owner and possessor is required to comply with the provisions of the legislation. That is carried over into the license, which is then issued to the possessor in terms of Section 3 and 24. Now, once that is the case, the interest and duty of the police is to enforce that law, as also contained in the license. Now, when that law is broken, the police have to make sure that they enforce it. That's where their interest is. And
No. Remember, the issue before us is basically whether the respondents may apply for a new license in respect of the same firearms. So they say that, and the SA agrees with them, they say that they want to comply with the law. They say, and I'm putting this in my own words, they say, in the past, the police authorities acknowledged that we deserved to possess these firearms. That is why they granted us licenses. They say the same need is still there. What happened is that the licenses expired, but the same need is still there. We want to comply with the law. We want to have licenses. What's wrong with that?
What is wrong with
the same
that
need is there, and I have not understood your case to be that need that was there, which is recognized by law and was recognized by the police authorities. I've not understood your case to be that need is no longer there to have firearms.
No, Acting Chief Justice, what is missing in your comment is what is actually an issue as raised by the applicant. The issue by the applicant is that whilst the respondent is entitled to apply for the renewal of the license, it is not entitled in terms of this legislation to possess after termination of the license. It cannot possess whilst reapplying where the license has terminated. That's the issue. Can they possess, continue to possess without the license? The argument by the applicants is that it is unlawful for them to continue to possess whilst applying because they are breaking the provisions of Section 3, read with 24.
Well, can I take what you have just said as a concession that you are saying the applicants accept that the respondents may apply for a license in respect of the same firearms? All that you are saying is pending that the outcome of that application or those applications, they may not possess the firearms. Do you want me to repeat that? Did you understand?
No.
You did understand what I said?
Yeah, I think I understood, but it may be repeated for...
Let me repeat it for you because I think
my benefit.
Your attention was divided.
Yes.
Can I take what you were saying? Can I take what you were saying as meaning that you accept that the respondents may apply for a new license in regard to the same firearms, but your point is simply that pending the outcome of that application, they may not possess the firearms?
Perhaps let me rephrase the submission this way. The applicant's position is that whilst the respondent is in unlawful possession of the firearms, they, on the wording of the act, may not proceed to present an application to the police for the renewal because the legislation requires them to surrender the firearms. Then they can apply. But whilst they are in possession, they may not apply because they are in unlawful possession of the firearms.
Okay, you talked about a renewal. As I understand the position, technically, the respondents are not talking about a renewal because, as I understand it, the application for renewal could only be done during the life of the previous license. They are talking, as I understand them, they're talking about a new application, but in respect of the same firearm. Maybe there might be a need to talk about the substance of the two regimes. But from what you are saying, it seems to me, and you must correct me, because if I'm correct in understanding you, it may be quite an important point you are making, namely that as long as you just want them to return to surrender the firearms, once they have surrendered the firearms, as far as the applicant is concerned, then they can apply. There's no problem with that. And the police authorities will consider their application in accordance with the law. Oh, is Mr. Shagwane muted now? I think he seems to be frozen.
I do think he has been frozen.
Yes.
Acting Chief Justice.
Yes. I guess that we just have to wait. Mr. Shagwane, you'll tell us once you're back.
Acting Chief Justice, perhaps we can ask the technician to make contact with him. To try
Yes,
and make contact with him.
yes. Zunaid, you please make contact with him.
ACJ will do.
Yes. What is it showing?
I can see you are back, Mr. Shagwane. Can you hear me?
Yes, I've borrowed a laptop from Mr. Nsoma. Mine is acting up. I don't know what's
Oh,
happening.
okay, all right. I was saying that I want to make sure I understand you correctly because what you had said may be quite important. Are you saying that once they have surrendered the firearms, from your point of view, the applicant, you accept that then they may apply for new licenses in respect of the same firearms, but they can't do it before they surrender the firearms?
Yes, that's the submission.
That's the submission.
Yes.
Oh, okay, all right. So you are with them on saying that they may apply for new licenses in regard to the same firearms. The only difference between the two of you say, is that they may not do so before they surrender the firearms. They take the point that they don't have to surrender the firearms before they apply. That's where your differences are. Is that correct?
That's where the difference is. And in my additional submission to that is to say, insofar as the legislation constitutes a law, what perhaps they may do is to apply for an interdict to the extent that they can justify their position before a court, to say, pending our new application for the firearm license, the firearms should not be destroyed by the police. So,
Yes.
so that will constitute compliance in our submission.
Yes. So you say, if they surrender the firearms today and they put in the applications for licenses in regard to these firearms today, from your point of view, unless there is a court order, you would be planning to destroy those firearms before the outcome of the application?
Not necessarily planning. My submission is that in terms of the legislation, the firearms may be destroyed, but not necessarily that it's planned that they are going to be destroyed. Let me put it this way. Let's say they surrender them, and contrary to what the acting Chief Justice suggests, they don't put in the new application, and some time lapses without any action, then they may be destroyed.
Yes.
But if they surrender and then they put in their application, that's a different scenario altogether.
Yes, of course, because it would not make sense for you to take the view that they are allowed to apply for new licenses in respect of the same firearms, and yet you destroy them before the outcome of their application.
Indeed.
Yeah. So your position is, if they surrender the firearms and immediately make applications for new licenses in regard to the same firearms, you will wait for the outcome of the applications. You will not destroy immediately. You would only destroy if a long time lapsed after they have surrendered the firearms without new applications. That's what you are saying.
It put it a little differently, it would be that, say, in the event that a distraction is then intended or planned, I'm sure they'll be given notice to say, you haven't done what you should do.
Yeah.
Now we're giving you notice that we're going to destroy this.
Yes.
And then if they have any grounds and they are still not able to put through an application at that time, or the application was unsuccessful, then they can approach a court. Otherwise, Acting Chief Justice, it's going to make the job of the police in implementing the act impossible. There's going to be so many of those firearm owners who would want to do the same. So the control as intended by the legislation will be lost or very difficult.
Yes. Okay, no, that's fine. So the position is there is agreement between the parties that they may apply for new licenses in regard to the same firearms. There is the question simply of whether they may do so before they surrendering the firearms, or they may only do so after they have surrendered the firearms. And all you are saying, surrender the firearms, and once you have surrendered the firearms, we are not going to immediately destroy them. You will have a reasonable time within which to lodge your application for new licenses. And if we plan to destroy the firearms, we will follow due process. We will notify you. And if we can't agree, you want to go to court, you will have that opportunity. We won't just destroy them without notifying you, so that you can take whatever action we need. But you are also saying, if you have filed your application for new licenses in regard to the same firearms, we will wait for the outcome of that application. That's what you are saying.
Indeed, Acting Chief Justice.
Thank you.
Thank you, Justice.
May I follow up on that, please?
Justice,
Sorry.
if you're finished with your questions.
Let me start with Justice Theron.
Thank you, Acting Chief Justice. Mr. Shukwana, if I can refer you to section 139, please. 139 subsection 4A. It says a person who surrenders a firearm in compliance with an amnesty notice, that's the notice published in terms of subsection 1, may apply in terms of this act for a license in respect of that firearm.
Sorry, Justice Theron, I just want to have access to that specific section on the electronic version. Perhaps in the meantime, may I humbly request that it be repeated, and I can answer it even when I don't say it.
Section 139, 4A provides that a person who has surrendered a firearm in compliance with an amnesty notice issued in terms of subsection 1 may apply for a license in respect of that firearm.
Yes.
Do you have the section, Mr. Shukwan?
Yes, I get it, please.
Yes. Is there any section in the act that says a person whose license has expired can reapply or can apply for a license in respect of that firearm, and under what conditions, apart from section 139(4)?
I'm not aware of another section in this legislation which says that. But the relevant section that I had was is 28, which provides differently.
What does section 28 say, Mr. Shakwan?
It refers to termination of firearm license. Then it says a license issued in terms of this chapter terminates upon the expiry of the relevant period contemplated in section 27, unless renewal in terms of section 24.
Now, that's the question that was decided by this court in Hunters, is that not right?
Yes.
And if you look at paragraph 19 of Hunters,
Yes.
where the license has expired, the gun owner must dispose of the firearm.
Yes.
Well, let me rephrase that. If you look at line 4 of paragraph 19, it says the gun owner knows that he must apply in time for renewal or dispose of the firearm before expiry.
Yes, that's what it said.
Yes, if the gun owner does not do that, the gun owner will be guilty of an offense.
Yes. That's what it says, Justice Theron.
Now, isn't this what this case is before us as well?
That is our submission, as it also appears in paragraph 21 and 22 of our head.
So what is the issue, Mr. Shakwane?
The issue here is what the SCA had pronounced, to say there is nothing in the act which prohibits the respondent to apply for a license whilst in possession of firearms.
Where does that appear in the SCA judgment, Mr. Shakwane?
We'll go to
that the gun owner can apply for a license while in possession of the firearm.
sorry, Justice Theron. I just want to go to the judge. Where did I put it? If we go to paragraph 33. Oh. Yes. The judgment is in volume 4. At page 421. If you ladies, sorry, if Justice Theron, you go to paragraph 33 there, it says the respondent's argument on this score cannot be sustained. In fact, if I may just start from 32. In my view, the respondent's reliance on S.A. Hunters is misplaced, and more fundamentally, it appears that the respondent's submissions are as a result of a misconception on their part of the true nature of the relief sought by Fidelity in this court. Paragraph 5 of Fidelity's amended notice of motion sought in the alternative to the principal relief, open brackets, i.e. renewal of expired licenses, close bracket, expressly seeks an order directing the commissioner as registrar to accept new applications, albeit in respect of firearms previously licensed to it. And in 33, it says the respondent's argument on this score cannot be sustained, for its edifice rests upon unstable foundations. there is nothing in the Act nor the regulations that even remotely suggests that someone whose license is terminated by the operation of law is as a result forever precluded from applying for a new license. To interpret the Act in the manner contended for by the respondents would, to borrow the words from Endumeni, be to cross the divide between interpretation and legislation. The effect of this is as the Act provides, that anyone wishing to own a firearm must apply for and obtain a license in order to lawfully possess such firearm. This is precisely what Fidelity attempted to do when the respondents refused to accept its applications. Thus, first-time applicants and repeat applicants alike are eligible to apply for a firearm license. Once an application has been submitted to the relevant designated firearms officer, it would thereafter be up to the commissioner, qua registrar of firearms, to satisfy himself or herself that the applicant consent meets the requirements stipulated in the Act and regulations. In persisting in its opposition to the relief sought in paragraph 5 of the Fidelity's notice of motion, encapsulated in paragraph 4 above, the respondents conflated the true nature of that relief with the principal relief previously sought by Fidelity, unmistakably disavowed in its supplemented practice note. Then in paragraph 34, that's where they proceed to say the above interpretation is reinforced by section 149 of the Act, which provides inter alia that a firearm may only be destroyed as prescribed, and that it remains the property of the owner thereof until its destruction. Should a person not be allowed to apply for a new license for a firearm in respect of which the license has expired, that firearm will have to be destroyed. In this case, some 7,000 firearms, an interpretation of the Act in terms of which firearm owners whose licenses have expired are prevented from applying for a new license and are required to buy new firearms only for the same application to be considered for a new license as envisaged in section 3 and regulation 13 is neither sensible or businesslike. So that is the part of the judgment that the applicants have a problem with.
What is the applicant's problem, as you put it, Mr. Shakwana, with that part of the judgment?
What this sentiment or findings are saying is that on an interpretation of section 3 of the Act, the firearm possessor, after termination, is entitled to proceed without more to apply for a new license. Now, the applicants are saying the legislation requires the person whose firearm has terminated to surrender the firearms, and then they can apply.
Mr. Shakwana, where does it say that where in the Act does it say where a firearm has been surrendered, the person may reapply for a license in respect of that same firearm?
No, it doesn't say that the person may reapply in respect of the same firearm. What the applicants here are saying is that the respondent wants to apply for a new firearm license.
Can we forget about the respondent's case for a minute, please?
Yes.
Can we look at what the legislation says?
Okay. The legislation, section 3,
And where does the legislature provide that somebody who has surrendered their firearm, where the license has expired, can reapply for a license for the same firearm?
There's no provision to that effect.
But you are saying that that is the legal position,
No.
that a person whose license has expired, even after, please let me just finish the question, Mr. Shakwane. If I understand you correctly, you are saying on behalf of the applicants that a person whose license has expired must surrender the license, then they can reapply for a license in respect of the same firearm.
My submission, Justice Theron, is this. On an application of this law, a person whose firearm license terminates is required to surrender the firearm. However, in the context or instance of a party like in the present case, whose license has expired, but says, I intend to apply for a new license for the same firearms, one has to try and think what the possible means they are, which can still be within the confines of the law.
Sorry to stop you there, Mr. Shakwane. I don't think we should think what the law should be. We should be guided by what the law says.
Yes, and in this case, that guidance has to be obtained through interpretation and suggestions in that regard. That's what I'm trying to do, which I had done during my response to the acting Chief Justice questions. The suggestion I provide as part of trying to interpret this provision is that the wording and context is that when the license has terminated, the possessor must surrender the firearm. But in order to accommodate people in that context, my suggestion and submission is that probably it could be said that whilst the firearms have been surrendered, and that party entertains seriously the intention to apply for a license to continue to possess the same firearms, then they can do so. And the police will probably be reasonable in that regard to say, bring in your application, but to the extent that they may intend to destroy the firearms.
Before we go to destruction, Mr. Shakwane, you say that is your suggestion. And your suggestion, your suggestion is based upon? Your suggestion that the person whose license has expired should be allowed to apply for a new license in respect of the same firearm is based on your reading or understanding of the Act. Is that what you're saying?
No, it's based on my understanding of the rule of law and the provisions of, amongst others, Section 9 of the Constitution.
Yes, Mr. Shakwane, then you would say that this court's decision in Hunters was incorrect then, and that decision would not have been based on the rule of law.
No.
If you look at, let me just finish, please. Please look at paragraph 19 of Hunters.
Yes, I'm looking at it, Justice Theron.
The question the court was answering appears in paragraph 18. The question is, what flows from the time lapse termination? Look at the third line, what are the legal consequences that flow after termination of the license. Paragraph 19, this court answered that question. It says, where the gun holder is in possession of the firearm and the license has expired, the gun owner must get rid of the firearm. And I repeat what I pointed, the section I pointed you to earlier. The gun owner knows that he must either apply in time for renewal or dispose of the firearm before expiry of the license. If he does not do that, he will be guilty of an offense. He knows what is expected of him before the expiry of the license and is provided with legislative means to fulfill that expectation. Then ends by saying that the rule of law, requirements of clarity and certainty are clearly met. Now, the argument you have been advancing this morning based on the rule of law is slightly different to what this court found in Hunters. Would you agree with that?
Yes, that submission came in the midst of the exchanges that were occurring between me and the acting Chief Justice. But our submission and case is as contained in our heads of argument. We rely on that express finding and decision of this court. If Justice Peron looks at page 7 of our heads to 8 to 9, that's the case we are advancing. But when engaged in this hearing, those are the suggestions I made.
So please can you explain to me what is the case you're advancing, Mr. Shakwana? On behalf of the applicant.
On behalf of the applicant, the case I'm advancing is found in paragraphs 20 and 22 of our heads.
And what is that?
That the respondent failed to renew the license within the terms of the legislation. And in terms of the decision of this court, the firearms have to be surrendered and they have to be destroyed.
Now, on the issue of destruction, I know I had stopped you just now when you were going there. You spoke about a notice of destruction and that before the police destroy the firearm, they would give notice to the gun owner. Where in the act is that notice made provision for, Mr. Shakwane?
No, that was not on the basis of the act. It was on the basis of suggestions I made when was interacting with the acting Chief Justice on the suggestion, the comments that came from the court.
But doesn't the act also provide for notice?
I don't think it makes that provision specifically. It's only when it comes to the section that you read, Justice Ron, where the amnesty issue is involved.
Yes, I may be wrong, but I do think that the Act makes that provision.
Yes, that's in section 136(2), if I may help. 136 sub 2.
Yes, but I think for now I've taken enough time. Thank you, Mr. Shakwana.
Thank you, Justice Daron. Justice Majid, I think you had indicated you wanted to put some questions.
Can I continue? I had left off with 1362. Mr. Shakwana, if you look at section 1362 of the Act, it makes provision that, first of all, let's start with sub 1. Sub 1 says the registrar of firearms may, in respect of a firearm or ammunition seized or surrendered, forfeited to the state, publish a notice in the Gazette. Once a notice is published, a person in subsection 2 who has a valid claim to that firearm may make representations to the registrar. That's the first aspect that I'd like to leave with you. Now, bearing that in mind, section 149, you must stop me if I'm going too fast, Mr. Shakwana. You are with me on 1361 and 2.
Mr. Shakwana?
Yes, I've muted.
Okay. So the first point is there's an opportunity for representations after a notice in the Gazette. Second aspect then is section 149(2) says a firearm forfeited to the state in terms of this act must be destroyed by the state within 6 months of date of forfeiture or after appeals have been exhausted. And B, remains the property of the owner thereof until its destruction.
Yes.
Now, bearing in mind those two provisions, do you say that in this either 21 days of representations or in the 6 months before destruction occurs, the gun owner has no right to apply for a new license? First of all, we know that renewal is not possible because SA gun owners, the SCA said renewal of a lapsed license is not possible in law. So do you say the gun owner cannot apply for a license in respect of those firearms in this period? Is that the case of the applicant?
No, the gun owner can apply, but cannot continue to possess. 136 supports what the applicants are saying. It refers to the registrar in sub 1. The registrar may, in respect of any firearm or ammunition seized by, surrendered to, or forfeited to the state, issue a notice in the Gazette stating that it is the intention of the state to destroy that firearm or ammunition. So the submission, the submission and case of the applicants is that they are entitled to apply, but they are not entitled to continue to possess after the license had terminated. They must surrender the firearm.
Yes, so that argument is the same in respect of the 6 month period.
Yes.
Now, can I ask you about the passage that was put to you in the SCA judgment? In the SCA judgment. I'm going back to the SCA judgment in this particular case.
Page
the SCA,
1.
Yeah, in the record.
421.
Yes. Let me take you to paragraph 33, which you've also read. There's nothing in the Act nor the regulations to suggest that someone whose license is terminated by the operation of law is, as a result, forever precluded from applying for a new license. You accept that as correct? You said so. You said so earlier to my colleague Justice Taron.
Sorry, Justice Majid. Paragraph
33, the second sentence. You have no quarrel with that. There's nothing in the Act nor the regulations that even remotely suggests that someone whose license is terminated by the operation of law is, as a result, forever precluded from applying for a new license. You have
no,
I
would agree with that in the context of the provisions of the Act.
Yes, and just tell me again, why do you say it's in the interest of the public and of SAPS to have a situation where, because as I understand it, in the present instance, Fidelity will have to surrender around 700 plus, give or take a few, 700 firearms to SAPS. SAPS has to keep it, has to enter it into the register, keep it there for safekeeping until it decides to destroy and give notice and so on. But in the meantime, after having surrendered, then Fidelity can go on and apply for a new license in respect of those same firearms. That's what you said to the ECJ, not so?
That was my submission.
But why do we need this convoluted, complicated system of surrendering when the applicant, which previously qualified and which clearly needs it in respect of its operations, has to then surrender it and apply afresh? I don't understand. I still can't wrap my head around why we should have this procedure.
The answer to that, Justice Majid, is in page 10 of our heads, page 10 to 11. It is the law. It is the law in terms of this legislation. To the extent that the respondent wants such a situation, or the court would want to condone the situation, then there must be a challenge by the respondent in respect of the legislation that it violates their rights in one way or another, or it's invalid for one other or other reason, particularly in that it does not make provision that someone who owns and possesses such large number of firearms, but has a lapsing period going in without them doing anything, should be required to surrender. As we speak, and from the wording, they are required to surrender.
And just the last aspect, you were asked right in the beginning by my colleague, Justice Mhlantla, about the differentiation the Act makes between possessors and owners. And you say that's an artificial separation. You say, for example, in the present instance, the license holder and the possessor possesses on behalf of the owner. Is that what your argument is?
That's my subject.
In other words, Mr. Wenzel possesses not for himself, but on behalf of Fidelity.
Yes.
Yes. Yes. Thank you. Thank you, ACJ.
ACJ?
Thank you. Yes, Justice Pillay.
Two questions, Mr. Skosana, that Shakwana, sorry. Shakwana, that you didn't quite answer in relation to questions put to you by the ACJ and by Justice Duran. The first, Justice Duran put to you that, asked you where in the judgment of the Supreme Court of Appeal it says that surrender is that the gun owner does not have to surrender pending an application. On my reading of the Supreme Court of Appeal's judgment, I don't see that it touches on or interferes with that provision in the Act that says a person without a license may not possess, so they must surrender. That's the implication.
Well, Justice Pillay, in my respect submission, it does, because when one reads paragraph 32, that court says it disagrees with the case and argument of the applicant. And the case and applicant argument of the applicant was exactly that they cannot possess and continue to possess. In these circumstances, they must surrender.
But paragraph 33 simply says that a gun owner is not precluded forever. There's nothing about not surrendering. There is that obligation that stands. So that's is that the provision you're relying on? Because I'd like to move on to the next question.
Which provision, Justice Pillay?
You're relying on paragraph 33 of the Supreme Court of Appeal's judgment to support your stance that it says that a gun owner who's in unlawful possession does not have to hand over the firearms pending an application, a fresh application.
No.
That's what you're relying on.
No, if one needs to read those paragraphs and then take into account the context, what paragraph 32 says.
Okay, I've read it, and sorry, I don't want to interrupt you unnecessarily, but you've read it to us and we're familiar with it. But it's your indication that paragraph 32 and 33 then is saying, on your understanding, that a gun owner who unlawfully possesses does not have to hand over pending an application, a fresh application.
Yes,
is that what you're saying? Okay.
Because they say the applicant's reliance on SA hunters is misplaced.
Okay, then the next, going to paragraph 44 of the judgment seems to have been quite cautious in restricting its order by excluding paragraph 6 of the prayer and leaving it, limiting it to only paragraph 5, which means that Are you with me?
Yes, Justice Pillay.
Okay, so moving from paragraph 44 to paragraph 6 of the order granted, all it says, apply for fresh or new licenses to possess a firearm in relation to those in the Annex J, etc. But by excluding any remedy under paragraph 6, would you not say that the authority has been left with the licensing authority to determine how the fresh application should be processed?
Yes, that may be so, but it did not uphold the case and contention that they cannot continue to possess. They must surrender the fire.
Yes, it said, in my view, I agree with you if that's what you now say, that Supreme Court of Appeal does not say anything about surrendering or not surrendering the unlawfully possessed firearm. Then I want to move to the question that you didn't answer when the ACJ put to you. My understanding of the question was that, is there a policy consideration underpinning the requirement or the legislation, as you now say it is, that you may not apply for a fresh license at all?
No, there's no policy consideration to that effect. And it's in fact the position that one is entitled to apply is reinforced by the section 136 that Justice Majid read.
So there's no policy consideration in, well, Justice Turan put to you that there is no provision in the Act, except in the amnesty provisions for a reapplication.
Yes.
But in relation to expired licenses, there's no such reapplication provision. Now, are you saying that if we were to find that there's no that there is no provision for a reapplication for an expired license, then you're also agreeing that there is no policy provision underpinning that the state of affairs?
Indeed.
Thank you. Thank you, James.
Thank you. Mr. Shakwane, let me ask you this question, but I think Mrs. Neyman must think about it. He will have to deal with it when he arises. What would be the purpose of the provision of the Act that says the license terminates, that is section 28(1)(a), terminates unless renewed in terms of section 24. If the position is that you may apply, which is not under section 24. I think that would be under section 3, if I'm not mistaken, or 6, I can't remember. If you may apply for a new license in regard to the same firearm. In other words, section 28(1) says the license you possess terminates if you fail to renew. And we understand renew to be renewed within before the expiry of that license, because that's what section 24 seems to provide for. So it says the consequence of you failing to apply to renew or to apply for a renewal is the termination of the license. Now, if one adopts the approach, and I accept that, I think you are not fighting with the respondent on this, but it's a question that needs to be asked. If when you have failed to renew your license in terms of section 24, you may apply under another section of the Act to obtain a license in order to lawfully possess the same firearm. Does that not defeat whatever purpose or objective section 28(1)(a) had? Namely, if you have not renewed your license and the period has expired, then the license terminates. Because if you apply under another section for another license, it means you will be able to continue to be a licensed firearm possessor. So what was the whole point of terminating the previous license? Did you understand my question?
Not quite, Acting Chief Justice.
Okay, can I try again? I think I was not as elegant as maybe I should have been. Section 28(1) says there is a consequence to your failure to apply to renew your license. And that consequence is the termination of the license. Okay?
Yes.
You fail to renew in terms of section 24. The consequence is you lose the right to possess. Okay? Section 24 contemplates an application for renewal that is made before the expiry of the license.
Yes.
Okay. Now, both what you say and what the respondent says and what the SCA says suggests that you can undo that consequence by simply applying for a new license under, I think it's section 3 or section 6, I can't remember. You can undo, you can effectively restore the same regime that section 24(1)(a) seems to visit upon you for your failure to renew within time.
Yes.
So my question is, what purpose, if we were to accept that you may apply afresh for a license in regard to the same firearm, if you failed to apply for a renewal of the license that had previously been given to you in regard to the same firearm, if we say you can apply, the question, and you can be granted, the question is, it means you can undo or escape the consequence that section 28(1)(a) seems to visit upon you for failing to renew your license. And the question is, what purpose would section 28(1)(a) then serve if that is how it can be undermined?
Yes, it will serve no purpose, Acting Chief Justice. And it will mean that the courts can ignore that provision and then impose alternatives as it's been suggested, which the applicants in paragraph 25, for example, of the volume 4, of the record, page 25, are stating to say that cannot be the case. The provisions of the section have to be enforced. And a party that needs to act in the manner that the respondent asked the SCA to order must find the relief in, amongst others, section 136.
Because if the interpretation of the SCA is correct, and if the interpretation of the respondent is correct, does it not mean that I can effectively, if I want to, if it won't cause me any prejudice, I can say, well, I don't have to bother to stop whatever else I'm doing and rush to apply for a renewal before the expiry of this license, because in any event, for the next 6 months, I won't be needing to use this. So I'll just apply afresh, and I can get a new license. So I don't have to really try and squeeze in this application for a renewal. That is now if I can do without the license for some time, which obviously wouldn't be the position with the respondent. But it means you can achieve effectively through a new application what you fail to achieve through an application for renewal. Or does it not mean that?
That's the unacceptable mischief which the applicants say should be prevented, and which is hit by the limitations in terms of Section 36 of the Constitution. It's unacceptable.
But of course, Mr. Shagwane, you made your submissions. We know where the applicant stands on the matter, but as the court, we've got to look at all scenarios, because if we give a judgment, we can't just give a judgment on the basis that Mr. Shagwane considered this, because when we pronounce, that will be the law. We've got to satisfy ourselves that what we say the law is the law. But Mr. Snyman will address that issue when he rises as well, namely the question of what purpose the provisions relating to the termination of a license serve in the case of failure to renew, if an application not under Section 24 but under another section may be made.
In effect, Acting Chief Justice, our submission is manifested in paragraph 24 of our heads. We say that will work if that position, as the Acting Chief Justice espouses it, which the respondent seems to be arguing for it and the SCA seems to be supporting, is against the principle of legality which courts should uphold.
Yes, but you have to say that it's also in line with the position you took earlier on.
Which was, Acting Chief Justice?
They have the right to apply, but they must surrender the firearms.
Yes, mine was a bit milder because it doesn't say, as the SCA sentiments implies. It doesn't include that fact.
Yes.
That they must surrender. Yes.
Okay, thank you. We are at 11:30, colleagues. If there are still colleagues who wish to put questions to Mr. Shagwane, maybe I should allow that, or maybe we should take the tea break and come back. Were there colleagues who still wanted to put questions to him?
Just one question. Question, ACJ.
Okay.
Mr. Shagwane, in your debate, during the debate with the ACJ, you submitted that order for the firearm not to be destroyed, the owner would have to bring an application, an interdict, in order for it not to be destroyed. I'm bothered about that submission because if he remains an owner, and if Section 149 provides that he remains an owner and that it can be destroyed within 6 months, I'm asking whether you still making that submission that it can be destroyed. Let's say it can be surrendered today and destroyed the next day, unless an application has been, or are you now willing to accept that Section 149 may be interpreted in such a way that he remains an owner, at least 6 months has expired? I just want to understand what your submission is.
Yes, Justice Chikli, my submission will later had to be qualified during the exchange between me and Justice Majid, which pointed to the relevant provisions in 136 and related provision that the legislation actually provides them that latitude. And it's in that context that if perhaps they fail, what I can say now, it's only if they failed in that context, they will still have the right of access to court to bring whatever.
Let's say the owner did not apply for amnesty in terms of 136.
Yes.
But my question is based solely on 149. Let's say the owner realizes that they did not apply to renew the license as prescribed. Then they comply with the law, and then they come and surrender the firearm. I'm saying, in terms of Section 149, they still remain the registered owner of that firearm.
Yes.
And I'm saying, in those circumstances where they don't apply for an amnesty in terms of 136, but they simply surrender it, is it necessary to bring an application to prevent destruction of a firearm before the expiry of 6 months?
Not before the expiry of 6 months. It must be after the legislated period.
Thank you. Thank you, ACJ.
Thank you. I think there was another colleague who wanted to say, was it Justice Rogers?
Yes, if I may just ask a couple of questions. Mr. Shakwane, if Fidelity were to bring applications for new licenses in respect of these firearms for which the previous license has lapsed, they would be brought, I think, under Section 20 of the Act. Is that right? That deals with a license to possess firearms for business purposes.
Yes.
And subsection 2 of Section 20 says, subsection 1 says, a firearm in respect of which a license may be issued in terms of this section is any firearm other than a prohibited firearm. A firearm in respect of which a license has lapsed doesn't fall within the definition of a prohibited firearm. Am I correct? A prohibited firearm has a specialized definition in this Act. So the 700 firearms that Fidelity is talking about are not prohibited firearms, as I understand it.
In my submission, in the context of Section 3, they are prohibited because the section speaks expressly refers to general prohibition in respect of firearms.
Yes, but where is Section 4 deals with prohibited firearms. It says the following firearms are prohibited and may not be possessed or licenses except under certain sections, and then that's a fully automatic firearm, cannons, and certain. So
Yes.
section 4 tells us what prohibited firearms are.
Section 4 specifies what appears to be prohibited in terms of providing a license.
Yes. So, and then if we proceed from the premise that the firearms which have been licensed to Fidelity and which the licenses have now lapsed do not fall within that category of prohibited firearms identified in section 4, then isn't the crucial question in deciding whether the SCA's judgment is right or wrong to say, is there anything in section 20 that takes these 700 firearms outside of the scope of firearms in respect of which an application to possess may be brought? Because it seems to me that the only limitation is in respect of prohibited firearms. There's, as I read section 20, there is nothing that says a person who is currently in unlawful possession of a firearm may not bring an application in terms of section 20. It would be an implied prohibition if there were one.
Yes, in a sense that section 20 cannot be read in isolation from section 3 and 136.
Yes, but so if we can, do you accept the proposition that in order to find that Fidelity in this case cannot bring an application under section 20, one would have to imply a class of persons who cannot bring an application under section 20?
I don't think I understand that proposition.
In order to find that Fidelity cannot bring an application in respect of the 700 firearms in this case, one would need to read into section 20 some prohibition that a person who currently unlawfully possesses firearms may not apply for an application for a license to possess them.
No, Justice Rogers, I do not agree. Section 20 provides for a specific situation, and what behoves to the matter before this court is section 3, read with 24, 28, and 136, amongst others.
Yes, section 3 creates an offense.
Yes.
Section 20 creates an administrative procedure to apply for a license. And as I read it, it is any firearm for which a license may be applied other than one which falls in the category of prohibited firearms.
Yes.
And we're not talking about prohibited firearms.
No.
So I don't want to repeat it. I won't repeat the point that it seems to me then that in order to find that Fidelity cannot apply, one would need to read some implied prohibition. But then taking section 3, that seems to be a separate provision. It simply says that Fidelity is committing an offense by possessing these firearms.
No, in my respectful submission, responding to that proposition, Justice Rogers, I'll make the following submission. Section 20 relates to the original application for the firearm license for the firearms as they are bought.
But I don't understand why where does this notion of an original and only one application come from?
No, the submission is this: when one goes to the decision of the SCA, the statement is made here to say that in paragraph 33, page 422, and they say, thus, first-time applicants and repeat applicants alike are eligible to apply for a firearm license. The point that I'm making is this: section 20 should be understood in the context that it relates to first-time application for the license. Now, once you have the license, the provisions of section 3 Section 24, Section 28, and 136 become applicable. If the license terminates, you must surrender it.
Well,
So
I'd like to come to that in a moment, but
yes.
Section 3 is a straightforward provision. It creates the criminal offense: no person may possess a firearm unless he has a license. That's all it says.
Yes.
So it seems to me a debatable point whether that in itself gives rise to an implication in Section 20 that if you unlawfully possess a firearm, you cannot apply for a license for it.
No. That can't be the case, Justice Rogers, because Section 24 expressly refers to the renewal of the license that is issued to you. If you do not do so, the consequences in Section 28 follow. And once you have those consequences, you surrender and you can deal with your position in terms of 136. You don't go, you don't have a fallback to Section 20. In my respectful submission.
Yes, but let us accept that if the license has lapsed, it's too late to apply for a renewal. But there's a significant difference between applying for a renewal and applying for a new license in respect of the same firearm, because you have to go through many more hoops when applying for a new license than you do for a renewal. That's the whole point of a renewal. A renewal is easier. So let us accept that Fidelity in this case has lost the opportunity to go through the easy process of renewing its licenses. It will have to go through the hoops of full applications for new licenses. So no. I don't think the mere fact that it can't apply for a renewal has any implications for whether it can or cannot apply for a new license. In fact, I understand you to say they can apply for new licenses provided they surrender.
Yes, my submission is that the consequences in paragraph 19 of the SA Hunters Act should follow.
So
surrender that.
So in terms of Section 20, you say they can apply for new licenses provided the firearms are then in the possession of the police rather than in their possession.
They must have surrendered them.
I have some difficulty in seeing where in the Act that state of possession impacts upon the ability to bring an application under Section 20. But can we then just go to the last question? It may be a technical matter, but where in the Act is it said that a person in unlawful possession of a firearm must surrender it?
It's implied in Section 136.
Why is it implied in Section 136? Let's just have a look at that. It's certainly not in Section 28. Section 28 says that if a license is cancelled, it's before its term ends by the registrar, then it must be surrendered. Section 28 doesn't say if your license lapses, you have to surrender it. I accept that you may expose yourself to seizure by the police, but I just want to know where the obligation to surrender actually comes from. Section 136 says, it says the registrar may, in respect of any firearm surrendered, issue a notice. But where is the obligation to surrender actually imposed? Surrender is a voluntary process.
No, it's not a voluntary process in these circumstances. It's one which is provided for by law. This court has spoken in paragraph 19 of the SA Hunters Act. Case. What are the consequences that follow in interpreting this legislation? So if Justice Rogers, your suggestion is that interpretation is incorrect, then
no,
this court
I'm not
must
suggesting that.
revisit
I'm not suggesting that anything in SA Hunters needs to be revisited. SA Hunters says that if you don't get rid of the firearm, you will be committing an ongoing offense. I accept that. Fidelity has been committing an ongoing offense since whatever the relevant date here is. It was April 2016 or 2017, I can't remember. It's committing an ongoing offense. Let us accept that. But where does the Act say that it has to surrender it? If it doesn't surrender it, it carries on committing an offense. But where is the obligation to surrender?
The Act does not directly say that, but this court, in its interpretation, which I submit also took into account directly or indirectly Section 136. In its interpretation, it said those are the consequences which follow. So we're asking the court to apply that law.
Would Fidelity be entitled to dispose of the firearms to a dealer?
No, well, not now. Now they are in unlawful possession, they must surrender.
And so they say they can't put them in, that they can't sell them to somebody who is entitled to possess them, namely a dealer.
In terms of the law, they must surrender.
Yes, thank you.
Mr. Court, please.
Okay, we are at 13 minutes to 12. I think we should take a break, but can I take it that there are no further questions from colleagues? So when we come back, we can hear Mr. Snyman. Yes, okay, all right. Mr. Shakwane, I think we have engaged you extensively. I don't think there is anything further you might be wanting to say. We can take the tea break, and then after that, Mr. Snyman.
Thank you, Acting Chief Justice.
Thank you. We will take the tea adjournment now. It's about 13 minutes to 12. Let's resume at 12:05. We adjourn.
Mr. Court, please.
Court will adjourn until 12:05. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin the video with video and sound when the hearing recommences at 12:05. Should you exit, you may use the same link to rejoin the hearing.
No.
It is 10:05 on 12 on my watch. Is everybody, all my colleagues in?
Acting Chief Justice and Justices, all counsel are online.
Okay. And all my colleagues are in?
Nope.
Just checking, Acting Chief Justice.
Okay.
No.
Yes, Acting Chief Justice, all justices are online.
Okay, all right. Thank you. Let us resume. Mr. Sneema, we have had the exchanges between members of the court and Mr. Shakwane. You know the issues. You may now address the court.
Acting Chief Justice, Justices, we are actually taken by surprise by the attitude of the respondents in their, or the applicants, sorry, Chief Justice,
I was wondering.
Their attitude was simply throughout the papers that there is a blanket prohibition you cannot apply after your license terminated. And that is borne out by the application for leave to appeal. And it's very pertinently dealt with in paragraph 12 of the replying affidavit. It's paragraph 47 to 450 of the replying affidavit, where they pertinently says, I may add that it was not the contention of the minister that once a firearm is terminated, a person is precluded forever from applying for a new license. It then goes on in paragraph 49 of the reply. It is the contention of the minister that once a firearm has terminated, that's most probably a license, the license ceases to exist, and the minister is only permitted in law to accept the firearm which has to be surrendered in terms of the Act. There is no provision in the Act permitting the minister to accept an application for such a firearm whose license have expired, and this is the contention of the minister. So their contention throughout, and this relates to all firearms where there's a license that is terminated. So just to give one example, when, and this is in the supplementary affidavit allowed in this application by Mr. Justice Davis, where Mr. Wenzel under oath says, we have in possession 12 firearms. Those 12 firearms were previously stolen from security officers, and those licenses terminated in the meantime because of non-renewal. You can't renew them when you're not in possession, and that's the regime applicable. With the result that they returned the firearms to the applicant, but the applicant were then precluded from applying afresh for a new license there. It's not through any of doing of the applicant that those licenses terminated. They were not in possession, or the respondent. The respondent simply says you cannot submit those, or the applicant says you cannot submit those applications. You cannot regularize that position. You had nothing to do with it lapsing. It is not your fault. And as a matter of fact, the regulation says those licenses are suspended. Now, in spite thereof, they still refuse on those 12 licenses an application to be submitted after the fact. Now, we have throughout and pertinently said that in paragraph, and if I may take the court to what we said in our answering or our opposing affidavit, page 4, paragraph 12 of the answering affidavit to the application for leave to appeal, we pertinently said, it is respectfully submitted. The expired license holder may do what the above honorable court indicated, and that's with reference to SA Hunters. It must hand the firearm over to the South African police for proper safekeeping because they no longer have the valid license. You may not possess. Possession is being determined. If I may remind this court as to the ownership of firearms, and this court in the matter of Van der Merwe
Okay, Mr.
and
Snyman, can I just take you back? Just give me that reference again to your answering affidavit. I missed that.
Answering affidavit, page 4 thereof, paragraph 12, Justice.
Okay,
Justice
thank you.
Majid. It's the latter part of that paragraph.
Yes.
So it's never
Page
been
page
our-
435. Page 435 of the record.
Mr. Justice Majid, if I may just explain on that, you would have seen from the application that was launched initially, and this was launched even prior to the SA Hunters case. First, the constitutionality was attacked, and then as an alternative there to say, listen, but we have tried to submit, return these firearms. You're refusing return. You said you can't take it because it's too many. We cannot return them, and that is why there was a Section 21 application that paragraph 6 of the notice of motion. So what remained after GOZA had been dealt with and after the SA Hunters had been dealt with is the prayer in terms of prayer 5, which is a new or a re-application, if we can call it that, in contrary to an application for a firearm on the first time. And then we've said, but in Section 21, give us a permit because you cannot take these in on your own version and rectify your system. And in argument before the Supreme Court of Appeal, it was quite clear that the court said, because we have indicated to the Supreme Court of Appeal that we have handed these firearms over to the police, there's no need to deal with the Section 21 permit order because we're no longer in possession thereof. And that's the basis. We cannot possess, it's unlawful to possess. Now, in terms of the Section 110 and in terms of Section 20 of the Criminal Procedure Act, if I'm in possession of a firearm which is in contravention of the legislation, it can be seized by the police. In terms of either of those and Section 111. And it is then to be dealt with in terms of this act. Now, this act doesn't say anything. Now, if I go to the police and I hand over a firearm because I am in unlawful possession, I do so in terms, and there's a form prescribed in the regulations, Form 522, 522A, and 522B. 522A deals with the surrender, 522B with the forfeiture. And there's a place where you must indicate, why are you surrendering it? Why are you handing it to the police? So it perfectly makes sense that I hand it in and I say, listen, it's lapsed, I hand it in, please do not destroy until I have you've processed the application. But the purpose of the re-application or new application, if we can call it. Now, if you go back to the Act and one reads the Act, there is nothing in the Act that says you have a right to apply. Nowhere for a new application for the first time or a new application after the termination. Nothing is said about it. It simply says that if you need a firearm or if you want a firearm or require a firearm, because need has got a connotation on it in terms of Section 13, if I require a firearm, there's a procedure to follow. And we say, as a result of me purchasing that firearm from a dealer, I become the owner. And correctly, in terms of the constitutional regime, the only aspect of ownership that is regulated is possession. And that corresponds with our common law position in respect of ownership. In the Van der Merwe's decision, which I referred to just ever so slightly earlier, and that is the decision, if you can be with me a moment, just to find my Van der Merwe versus, I've now jumped, sorry, Justices. I just want to see that I've my correct. Van der Merwe and another versus Taylor N.O. and others, 2008, 1 SA 1 Constitutional Court. And justices will remember that that is the decision where it related to ownership of money. And the court in paragraph 26, although it's the minority judgment, that was not the point at which the majority differed. They said ownership potentially confers upon the owner the most complete or comprehensive right of control over a thing. In Geen versus Geen, ownership was defined as the most comprehensive real right that a person can have in respect of a thing. It then says the point of departure is that a person can, in respect of immovable property in that case, do with and on the property as he pleases. This apparently unfettered freedom is, however, a half-truth. The absolute power of an owner is limited by the restrictions imposed thereupon by law. So we say, if I purchase the firearm from a dealer, I become the owner thereof. I pay for it. I may not possess it because the Act only regulates possession. The reason, therefore, being quite simple, it provides for a control over possession of firearms. A person cannot use a firearm as if he doesn't possess the firearm. And that's where the real mischief in the use of firearms lie. If you regulate possession, then you regulate the real problem where it can be a dangerous thing. So a firearm in general, I have ownership over, I apply. If I then is granted a license to possess, and it's a very simple differentiation also with a company. A company cannot possess. A company's ownership lies in the company, but the possession and control lies in an individual, a natural person. And that's why a natural person also in terms of the Act is the person who takes responsibility for the firearm. As a matter of fact, the license is issued to that person. And that person is deemed to be the license holder for the duration of thereof. That's in terms of Section 7 of the Act. So it is quite clear that there is nothing in the Act that prohibits you from an application for a new firearm. There's nothing in the Act that prohibits you from, even after the license terminated, from applying for a new license. It's a longer and more thorough process. What it does prohibit is possession. And if I go to the police station and I hand in my new license application for the license for the firearm whose license previously terminated, I am in our submission or the police is entitled to seize the firearm. But that doesn't preclude me from applying for a new license. It doesn't preclude them from they then still have a duty, the police, to process that application and to receive a proper explanation. Now, they may impose an administrative penalty in terms of the Act. They may even find that the applicant was negligent in not doing so, or was in unlawful possession and being negligent and not approve the license. And they can charge him. But to make it worse, if it is then charged, he then, in terms of Section 104, there's an investigation, and then he may dispose of the firearm to a dealer, even if it was unlawful possession, which is not the case if I'm not being charged. So if Mr. Justice Vroenemann's approach was correct, to say, but you are not going to be charged, it's not going to commission of an offense if you hand over your firearm, then I'm in worse off a position if I go and I want to apply, I hand it to the police, than if I get charged and I may dispose of that firearm. So in the circumstances, we say there's nothing prohibiting us from applying. In the ownership is an implied right to apply for possession. And the other side of that coin is the duty to process. And that's all we're asking. We're not saying you should approve that license. We're not saying there should be a fine. We said that immediately when we realized, and this is common cause facts, Mr. Wenzel took over, Mr. Aysel let them lapse. And why he let them lapse, there's an explanation therefore. He said, I took stock of what happened. I then wanted to renew. They said, we cannot renew, the licenses have lapsed. GOSA said that is the correct position. We then said, listen, but here's our firearms. We want to return them. According to, that is what we said in our founding affidavit. In the answering affidavit, an affidavit was sought to be set up by the designated firearms officer. It was never signed by the designated firearms officer, saying that he...
Can I just clarify something that bothers me? I put this question to Mr. Shakwani, but it still worries me because I worry about the provisions of 149. You are saying that effectively what the Supreme Court of Appeal said is that, and I'm referring to that page where you referred, Justice Majid, in 435, paragraph 12, that you remain the owner And that is my reading of 149. And then you then say, in the meantime, you submit that the holder must do what the above honorable court indicated, hand over the firearm to the SAPS for proper safekeeping. Right. Now, my question is related to remedy. If we're inclined somewhere in our judgment to say that you are required to hand it over, if we're inclined that way, and this is where my question is going, I'm worried about 149.2a that says that the firearm must be destroyed by the state within 6 months.
Justice, there's quite a simple answer there too. There's a process that must be followed before a firearm can be destroyed. Section 149, in fact, says, and it refers specifically to a firearm, and this is 149.2, any firearm, muzzle-loading firearm or ammunition forfeited to the state in terms of this act must be destroyed. So only once it is forfeited. So if I complete my form that it's forfeited, or if there's a declaration of forfeiture, but a seizure thereof is not a forfeiture.
So when you surrender, a firearm, 149 is not applicable.
Justice, it may become applicable if I do not then claim the firearm and they don't know what to do with it. Because at some stage, they can't just hold on to that for forever. At some stage, they say, you haven't applied for it. You seem to have relinquished your right. I'm going to destroy it if you don't get out of your blocks. They give you a notification, and I must then come along and I must say, because A says must be destroyed by the state within 6 months.
Yes, let me direct you to my problem, because we, at the end of the day, we'll have to draft a remedy in this. You seem from paragraph 12 to be saying that you would be willing to do what the SCA seemed, in your view, to be saying you must do. Hand the firearm over to the SAPS for proper safekeeping, because you no longer have a valid license, right?
Indeed, so, Justice.
My question is directed on the remedy that we would have to give if we're inclined your way. What would we then say? And is there no danger that within 6 months, bearing in mind the large quantities of matters that are at the SAPS, I don't know, how long they would have to deal with renewal of licenses or applications of licenses and all of that. And so that you understand the context of my question. I'm saying if you simply handed over these firearms to the SAPS for safekeeping, as you seem to be saying that you are willing to do, I'm worried about the text of section 149, because it says that they must be destroyed within 6 months.
Justice, it must be destroyed if it's forfeited. And that's why I've referred earlier to the two forms that are applicable. One is a surrender form, the other one is a forfeiture form. A forfeiture, I clearly, is either granted by the court in terms of section 103, or there's a declaration of unfitness, administrative declaration in terms of section 102, where you also have the opportunity to dispose of that firearm. But if it is seized by the police because I'm an unlawful possession, that is not forfeiture, because section 30 and 31 of the Criminal Procedure Act is not applicable, which deals with forfeiture. And then, Justice, if in terms of section 136, that I am then notified, and I've done nothing about this firearm, I've surrendered it, and I sit back, they then have a duty, if they intend to destroy the firearm, which is to be destroyed in terms of section 149, then, and in terms of section 136, any person who has a valid claim to the relevant firearm may, within 21 days after the publication of the notice of destruction, make representations to the registrar. Now, in those circumstances, I am the owner. I remain the owner. I have some interest in it. I cannot get compensated because of the provisions of sections 134 to 137 and the decision of Justice Alliance that was referred to in one of our submissions of the amici, and which we've attached, I've referred to. It is quite clear that once I am informed, I need not wait till then to make an application, because they say I can't make an application. So I at least have an implied right to apply, and I would submit that they cannot destroy the firearm until such time as they have dealt with such an application. They can only do so once there's a forfeiture or a voluntary surrender where you say it can be destroyed, because the forms ask that specifically. Now, just on the question of the time periods, we have submitted in one of the amici matters to place this court in a specific, in the light of what has happened and the time that has lapsed. According to the documentation available to the Parliamentary Portfolio Commission, Committee on Police, in August this year, there was approximately 342,000 applications outstanding, a backlog. It's a massive backlog that, according to most probably will take 18 months to 2 years to catch up with. That's roughly a time period that it takes to deal with an application. But I cannot be in possession of that firearm, and they cannot destroy the firearm if there's a pending application. And in your submission form, you indicate, I have applied. And they must notify you if they intend to destroy. And if they then want, you can then approach the court. But it's administratively taken care of in terms of the regulations and the forms that are there. So we need.
Thank you, Justice Chikwi. Mr. Snyman, if the position were that once you have failed to lodge your renewal application in terms of section 24 before the expiry of the license, there is nothing you can do. You can't apply for a new license in regard to the same firearm, and you can't apply for the renewal or extension of the license that has expired. The consequences would be quite serious for an entity such as your client. Is that not so? Because it would have to, in terms of business.
On business, Acting Chief Justice, it is a serious impact of the firearms are not cheap. It's estimated to be 16 million rand worth of firearms. Now, to have them destroyed and buy 16 million rand new firearms is simply illogical. It doesn't make business sense at all. We may not possess them. And we said that if you cannot take in these 700 firearms, grant us a temporary authorization to possess, which we take off from the police that administrative duty to accept and receive. They can even have in those applications where you apply for a temporary authorization, it can have a condition that you may not utilize it in the meantime, but you must keep it in your own safekeeping, for instance, if they deem that necessary. But that is up to the registrar to decide when such an application comes. If there is a need for that firearm in the meantime, one can do that, but that's not before the court at this stage. We simply say we have a right to apply, even though it is terminated the license, and we say we know that I cannot possess, I may not possess it. So either it's seized or handed over until it's been administratively dealt with, but the whole purpose of the act is to regulate the possession. And if I may not possess it, I cannot use it, and that regulation is then taken care of. If I have a need for that firearm, I can utilize the remainder of the tools created in the Act, for instance, Section 21, for a temporary authorization, but I must, in the circumstances and the blanket refusal to receive an application, a new or a reapplication. And earlier, you, Acting Chief Justice, it was asked why, what is the difference then, or there's not a real difference between a new application and a renewal. There is, I may not possess. But what makes it worse, it's nothing different from buying a new firearm. Because when I buy a new firearm, I needn't have to explain what happened to the old one. I hand it in, I buy a new one, and I apply for a new license. The only impact that has is an economic impact and the time period I have to wait for the processing of that license, which is similar to a new application. But it doesn't take away.
If you failed to lodge a renewal application in relation to the present license, the licenses that expired, and the correct interpretation of the act would be that you may, well, I think everybody maybe accepts that you are not precluded from buying a new firearm and applying for a license in regard to the new firearm. Now, would you not need to explain, would you not need to say to the police authorities or the registrar, I have previously had a license or licenses issued to me in respect of different firearms, and this is what happened. The licenses expired, I didn't apply on time, and this is what has happened to those firearms. I've bought a new one now, I'm applying for a license. Would you not need to explain that situation? In other words, you are not in the same position as somebody who is applying for the first time for a license.
Generally, Chief Justice, when I apply for a license for a new firearm, even if it's the first time I apply, I must explain whether I have previously applied and whether it has been, they've refused or confiscated it. I must explain that. So in the form, it is prescribed for us, if I recall correctly, it's section 2 or form 218, SAPS 271, sorry. They ask those questions and you have to comply with that. The simple issue is that if I buy a new firearm, I'm in no different a position than a person who's applying for the license or a relicensing, if we can call it that, a new application for the firearm he's already the owner of. So the approach is quite simple. If I go to a dealer, I buy the firearm. The firearms details is then completed on the form. I do my application, I submit it to the police. I've paid for it. It's in the possession of the dealer. And then as soon as it's approved, I am entitled to go and take it from the dealer. Now my license lapses. I cannot take it or terminates. I cannot take it to the dealer. I'm in unlawful possession. And then we say there is no difference between the first application and the second application, although I have to answer all those questions. But the ownership of the firearm is identical. I bought it, I purchased it, I may not possess it. In either cases, I may not possess the same. And our approach is possession is refused. And the only reason for section 24, Justices, is if one looks, if I apply timeously, i.e. 90 days before the expiry, in terms of section 24.4, that license will remain valid until it's decided. That's the only advantage you have. And after the 90-day period, I may dispose of it to a dealer, for instance, or I can get rid of it. But after I'm in unlawful possession, I cannot do so anymore. But my license still terminates at the end of that time period. So the only advantage of section 24 is it does not terminate. It remains valid until decided upon, which can take up to 2 years.
Now, I asked the question to Mr. Shakwana, and I said you would deal with it when you rise. Of course, you don't rise. The question being, what's the purpose of the provision that says if you don't apply for a renewal of the license while the license is still valid, that license terminates? What's the purpose of that provision if you can achieve the same purpose by simply applying afresh?
Chief Justice, I may not possess lawfully. I may not possess it lawfully. So if I go to the police, or even if the police stops me, or if they search my house, they may seize that firearm. It's unlawful possession, and they can charge me. What's then, in terms of section 28(1), it terminates, i.e. I may not validly or legally possess. But that doesn't change the fact that if I need to, or if I want to, I can apply for a license. Now, if my license terminated, as in the case of our client, in this matter where Fidelity's then responsible person, Mr. Aisel, relied on the SMS system, which was extremely unreliable, and he let the license lapse. Now a new responsible person comes along. He says, but listen, here's 700 that lapsed. We need to regularize the position. We can either hand them back, or we can ask that we be allowed to possess, and we apply. There's in principle no difference. I may simply, the possession is regulated.
But,
I may not possess.
But Mr. Snyman, isn't the position that if the intention was that you can still be given, you can still apply and obtain another license in respect of the same firearm? Isn't the position that all the act needed to say is that you can apply for a renewal even after the period has expired? Because then in terms of illegal possession, if you delay between the time of the expiry of the license and the time when you apply for a renewal. Now I'm talking about a regime if the act was saying you can apply for a renewal after the expiry of the license. During that period, you would be in unlawful possession anyway, okay? So why didn't the act, or why don't we talk on the basis that, well, all the act needed to do, if it intended that you could still have a license in regard to the same firearm, you can apply for a renewal even after the expiry.
Mr. Chief Justice, I would submit that the simple answer is possession. I may not possess this firearm at all. We say the application is not regulated. Even if I buy a new firearm, my first firearm, there's nothing that says I have the right to apply. That comes from either the Act, Section 20. Mr. Justice Justice Rogers referred to Section 20, which says I apply, and this is the basis I apply. I may apply for this type of firearm. It's not the tainted firearm doesn't all of a sudden become a prohibited firearm. It doesn't say I cannot apply again. What it regulates simply in our view is the possession. Secondly, it doesn't prohibit the fact to apply for a second license for the firearm, if we can call it that. But the Act is not ideal. There's a number of holes in this piece of legislation, and I can start out to show them, but one of these is simply, there's nothing is said about it. And that doesn't necessarily take away your right to apply. It regulates only possession. It doesn't regulate ownership. It says you remain the owner.
Do you accept that if you fail to renew within the period of the validity of your license, and then you subsequently apply not for a renewal because it's outside the period of validity, but for the issuing of a license as if it is for the first time. But in respect of the same firearm, if that application is granted, for all intents and purposes, unless the registrar attaches new conditions that were not attached to previously, you basically achieve the same legal benefits as you would have achieved had you applied for a renewal within the same period, except that during the intervening period, you may have been in unlawful possession. But ultimately, the benefits of the grant of the license, can be the same.
Mr. Chief Justice, our point of view is simply, if there is a requirement that I have to hand in my firearm before I can apply, that would not be unreasonable. But that's not the standpoint of the police. If the police says, I'll allow you to reapply in respect of this firearm license for the firearm that's terminated, but you must hand it in first before you can apply. It's not unreasonable.
You have no problem with that.
We've got no problem. Throughout, we've said that's the situation.
Yeah.
And we don't say we must remain in unlawful possession and you must process. That was not our point of view.
Yes.
And the whole point is, Acting Chief Justice, is that they said in their own basis, you can never apply. It's not as if, even if you hand it over, you can never, ever apply. It must be destroyed. You can buy new ones. And there's no difference between the scenario you've given to us and me buying a new firearm.
And
even penalize us with a fine or through administrative action on their side, but they cannot block us from applying, because that is what they're saying. As an owner, one of the incidences is most probably where possession is regulated. An incidence of that ownership is the right to apply to validly possess. And that never gets taken away if they then decide, listen, you've been an unlawful possession, is negligent, I'm not going to give you a new license, they're entitled to do so.
Of course, we know that Mr. Shagwane has said today, their position is you may apply, but surrender the firearms first. And then your applications will be considered and they won't destroy the firearms, at least pending the outcome of your application. And if they think they have to destroy, they'll follow due process and so on and so on. But if the position which I understood them to have taken initially, and I think that's what part of what you are saying, if the position was that you can never apply for a license in respect of the same firearm once you have failed to apply during the period of validity of the previous license, the consequences of that would be that you have to dispose of, in the context of your client's business, you have to dispose of about 700 firearms or so, but you can buy 700 or so new firearms and you will be applied to apply for licenses in regard to those. Is that a correct understanding of what it would mean?
That is exactly the attitude that's been there, Chief Justice, and that is where it's illogical. If one looks at the purpose of the Act is to stop the proliferation of firearms, it will mean 700 firearms is handed into the police. They can take 6 months or how long they need to destroy them. I can buy 600 new firearms. We want to limit the firearms in the country. That's the purpose of the Act, and regulate them. So if I hand that firearm to the police and I apply for a license for that same, there's not an extra 700 that comes into circulation, at least for say 6 or 7 months.
And the position is that on their approach as it was before today, that could happen to somebody who complies with all the requirements and does qualify to be granted new licenses. Now, somebody who is fit and proper, the certificate of competence is there, and they've complied with all the conditions under which the previous license was issued. They've done everything perfectly. That could happen to that kind of person or entity.
It could, Acting Chief Justice, and there's one of the examples we've given is the 12 firearms which the license had expired whilst it was in the possession of a thief, which was then to be returned to us. That's one example. The other one is to be found in Gun Owners Association made a submission. There's an affidavit by an individual down in Grootbrak in the Western Cape who says he made an appointment with the police 101 days before the lapsing of his license. That was on the 3rd of March this year. He went to the police station to renew his license. The designated firearms officer had resigned and there was no designated firearms officer. Chief Justice, in terms of the Act, all applications must be handed in and submitted to the designated firearms officer at your local police station. There was no designated firearms officer then appointed until July that year. His license lapsed through no doing of his own, with the result that that person is now penalized because he'd done nothing wrong. If the approach is correct, and that is not, I would submit, the purpose of the Act. You may not possess. I'm more than happy that that is the situation. And had that been the registrar's attitude throughout, I doubt whether we would have been here.
Yeah. Okay. Thank you.
Sorry, AC.
Yes.
Acting Chief Justice, can I just ask something of Mr. Snyman?
Yes.
If we can call what your colleague has said now as a concession, where does it leave the SCA's judgment? If the position that he now adopts is correct, does it mean that the appeal is simply dismissed because the declaration that the SCA granted is, on his view, unobjectionable? And I'm looking at the order as it appears in volume 4, page 427. It's a declaration that you are entitled to apply for new licenses in respect of these firearms. What is missing is anything which explicitly deals with what must be the state of the possession of those firearms in the intervening period. Assuming, I'm not 100% sure that they can't be in your possession when you apply, but assuming they can't be in your possession when you apply, would you have any objection to a proviso to the declaration from the SCA, provided that those firearms have in the meanwhile been surrendered into the possession of SAPS?
Mr. Chief Justice, and Justice Rogers, we cannot object there to. If that rider is there, that's the basis. We support it because if it's not my client, but if this is applicable and to be applied throughout, then that person cannot be in possession. It's unlawful. And if the requirement is that you have to hand it in to the police and then apply, we support that because that would that would achieve the purpose of the Act. Insofar as you know exactly where the firearm is, you've got certain obligations towards the registrar to show, for instance, where you're residing, all those kind of things, if the Act applies, which we support it. Even if that proviso is inserted, I would think that the SCA specifically did not deal with it because they left that up to the police to decide whether they will grant you then a temporary possession or not, because they may do that. But we support such a rider in this circumstances.
You said that previously the police had indicated that they didn't have capacity at the Florida police station to, as it were, store 700 firearms for a period of time. Is that practical? What are the facts, or what is the evidence in that regard?
The evidence was that we tried to, after they refused to receive the firearms renewal applications, we tried to return them and make new applications. They simply said they don't have the capacity and we couldn't hand them in. We therefore asked in such a circumstance, grant us a Section 21 permit to possess in the meantime to regularize our position. But because we'd handed in the firearms in the meantime, it became actually moot in the Supreme Court of Appeal. We don't need a Section 21 permit anymore because we don't have possession of it anymore. We've handed them in. So if there is a rider to say you must surrender it, it closes the door on a practical type of approach for the police to say, in these circumstances, we will allow you to possess in terms of Section 21. And I would submit that, logically speaking, that is most probably why the SCA steered clear of a specific rider to say it must be handed in. But we had indicated throughout that we had, by the time we got to the SCA, surrendered those firearms and that we're no longer in possession of those firearms. So in the circumstances, the rider is not a problem, but it may in certain circumstances, and I don't think one can trouble the water, but if that rider is imposed, we cannot and should not object to it.
But you say, as matters stand now, when the SCA made its order, the question of your still being in possession was academic because you were not in possession. They were with the police.
The police were in possession thereof, and Mr. Masoma, when we argued that matter, accepted that position. We are no longer in possession thereof. We've surrendered them.
It may be that reasons for judgment might have to say that if somebody else, if they were in a similar position to you, might need to hand in the firearms. But then, given that that was the state of the play when the SCA made its order, it appears to me, would you then say that if your colleague's concession is correct, then the SCA's order as it stands is unobjectionable and the appeal simply gets dismissed?
It is, Justice. It is.
Mr. Snyman, I assume you are done, Justice Rogers?
Yes, I'm done. Thank you.
You are done. Can I ask this question, Mr. Snyman? It appears to me from what Mr. Shagwane's position is today and what you have said, and maybe what you have always said, it appears that if after the SCA judgment, the applicant had approached you and said, we actually don't have a problem with the SCA judgment, or as long as you are going to surrender the firearms, there may not have been an appeal and we would not be here. Is my understanding correct?
That's indeed so, Acting Chief Justice. But yes, their attitude, I've indicated in their application, was quite different to Mr. Shagwane's, if we can call it a concession today.
Yes. Yes. Okay. Okay. All right. I think there was a colleague who wanted to ask a question.
If I may, Acting Chief Justice.
Yes.
Thank you. Mr. Snyman, Section 1394A of the Act provides for the surrender, or provides that a person who surrenders in terms of an amnesty notice may apply for a license in respect of that firearm. If the position of Fidelity is correct, and a person is always able to apply for a new license, would that not render Section 1394A superfluous?
Justice Tron, Section 139 stems from an amnesty. And under an amnesty, firearms that may be surrendered is not necessarily only firearms of which there was a previous license issued to that applicant or the person making use of amnesty. It might be a thief who gets possession of the firearm, and this grants any person who surrenders a firearm the right to apply for a license. One example, for instance, is quite simple. I am an estate firearm. The person passes away, the license terminates, and it now lands up in the hands of the executor. He passes it on to a person who's to inherit it. He's an unlawful occupation. He never had a license, but if there's an amnesty, he can then apply under that section.
But why would he need to apply under that section if anyone can apply, even after a license is terminated, surely that section 139, which allows the person whose license has expired to reapply. We're not talking about a third party now. We're talking about the person whose license has expired, isn't it?
If the license is expired, Justice Thron, we're dealing here with an amnesty. An amnesty is a declaration through a process by Parliament, which says we are granting an amnesty for illegal possession of firearms.
It relates to illegally possessed firearms, yes.
So illegally possessed firearms may be, for instance, an example like the one in an estate. There's a decision that I was involved in December last year of Sternberg. Sternberg brought 3 firearms as a professional hunter from an estate. The licenses in respect of those firearms lapsed because the import license, with the result that he could apply under section 1394 under the amnesty. He never had licenses for those firearms before, and therefore he can apply. But what we are simply contending is, if I previously had a license, I can apply. If I am a thief and I come to the police and I say, here's the firearm, and I apply, they're going to surely act in that respect. So that will stop an illegal possession in that respect. And this is simply applicable to amnesties. It's not applicable to the general run in our submission.
If the legislature envisaged certain situations in which an applicant can apply, why was provision not made for applicants whose licenses have expired?
The general authority to apply for a license stems from your ownership, and then the authority to apply in terms of section 20 or section 13 or 16 or 15, which regulates the license. As indicated earlier, section 21, a firearm in respect of which a license may be issued in terms of this is any firearm other than a prohibited firearm. And then if we go to section 6 of the Act, it specifically deals with the registrar may issue any competency certificate, license, permit, or authorization contemplated in the Act on the receipt of an application contemplated in the prescribed form. So even if I am a thief, if you're as brazen as that, and you apply for you have the right to submit the form, and they have the duty to process that and deal with it accordingly. So even if, and we say as an incidence of my ownership of a firearm, I have the right to submit. And that is clearly made provision for in section 6(1) of the Act, which says on the receipt thereof. And what the process the police is currently following is that they refuse to accept such an application. And that is common cause.
Now, I'm not sure if the Act says that you have a right to renew. Section 24 says that a gun license must be renewed 90 days before its expiry. Now, Mr. Snyman, you refer to a right to renew or to apply even where the license has expired. But section 24 specifically governs that situation. Section 24 says the application must be made 90 days before expiry. Now, if we accept the argument that you're advancing on behalf of Fidelity, it would make a nullity of the time period set out in section 24. What do you say to that?
Justice Tron, we do not agree with that statement. Simply section 24, if I apply timeously, section 24(4) says, if an application for a renewal of a license has been lodged within the period provided for in subsection 1, the license...
I'm sorry to interrupt you. That is not what section 24 says with respect, Mr. Steinman. It says
Milady, I'm reading
the holder,
section 24(4).
the holder, let's start with 24(1), the holder of a license issued in terms of this chapter who wishes to renew the license must at least 90 days before the expiry of the license apply to the registrar.
Indeed, so, Justice.
Yes.
But section 24(4) says, if I do so apply before the 90-day period, that license remains valid until it's be decided upon. If it terminates, I'm not renewing my license. It is a fresh application, and the renewal is dealt with in terms of section 24(3).
Yes, this is my question. Let me see if I can make it clearer, Mr. Snyman. Your argument on behalf of Fidelity would render section 24(1)(a) superfluous. 24(1)(a),
there is no one.
24(1) inserts a peremptory provision regarding when the application for renewal must be made.
Indeed, so, Justice.
If we were to say that that application can be made after expiry of the license, I beg your pardon, Mr. Snyman, did you want to say something?
Mr. Justice, Madam Justice, Justice Tron, I beg your pardon. Subsection 1 simply says, I have to apply if I want to renew it. If for whatever reason I am unable to renew, or if
I'm sorry, Mr. Snyman,
sorry, Justice.
Mr. Snyman, Justice Theron was still putting a question to you.
I apologize, Justice.
Just wait for her to finish, then you can answer the question.
Sorry,
Thank you,
Justice.
Acting Chief Justice. Would your argument, if it is accepted, not render section 24(a) nugatory? 24(1), so I keep on saying A, it should be 24(1). 24(1) says the license must be renewed 90 days before expiry. So if this court was to grant an order which goes against 24(1), what does that mean? If this court was to say, let's disregard 24(1) and the time limits in 24(1), let's allow gun owners to apply for licenses after their licenses have expired, contrary to the direct provisions of section 24(1). Would that be permissible?
Justice, in terms of the decision of the Supreme Court of Appeal in gun owners at the end, Gun Owners Association matter at the end of last year, they said it cannot be renewed after it terminated. It's impossible. So there is no renewal application made. And the only advantage of a renewal timeously is that you may possess until it's decided upon. If I don't renew it, I may not possess. And that is the simple answer thereto. The advantage of a renewal, if done timeously, is I may continue to possess until it is decided upon, on condition that I have obviously complied with subsection 3, and I've done so timeously. If I do not do so timeously, I may not possess the firearm, but that, we say, does not stop me from applying afresh. That means I may not possess that firearm.
What is the implication or the consequence on a gun holder in terms of section 24(1), or who does not comply with section 24(1)?
He may not possess the firearm, or secondly, he may, if it's within the 90-day time period, i.e. before the termination thereof, he may dispose of the firearm to anybody else. He can sell it to a dealer before it terminates. But before the 90-day period, he may renew. If he doesn't apply for a renewal, he must either hand it over to the police or or dispose thereof lawfully. If not, he's in unlawful possession and he may not possess the firearm. But we say that if it lands up or comes to a situation where you can no longer possess the firearm, that doesn't take away the fact that you may apply for a new license. I may not possess. And that's the difference between a section 24 renewal and an application to possess. If I buy a firearm the first time from a dealer, I may not possess it until I have a license. Similarly here, there might be a number of reasons why the person has been unable to comply with the 90-day period. The Act has no regime, therefore. It simply means I may not possess the firearm. But we say it doesn't take away a right to start afresh and apply and go through the whole system again, because you can no longer renew the firearms license.
Did I understand you correctly in your submissions to say that the judgment of Justice Froneman was incorrect?
No, Justice, not at all. He simply does not deal. He says the regime in terms of sections 28 and 24 is not illogical. He says in paragraph 21 of his judgment, where my learned friend referred to paragraphs 19 and 20 thereof, specifically, this may have an impact on your right to property and later on, but it's not illogical that once it terminates, you cannot possess after the fact. And that's all he focused on, is the irrationality of the two sections, sections 24 and 28 that was in play at that stage. We're not saying he was incorrect. He simply says, you may not possess, you must dispose of it, get rid of it. Now you may
Look at paragraph 19 of that judgment, Mr. Snyman.
Could you be with me a moment? Justice, I'll just get the right one in front of me. Is it this one? No. Is it that one? No. Justice, I have it in front of me.
In paragraph 19, the court deals with the consequences of where the license is not renewed timeously. It says the gun owner knows that he must either apply in time for renewal or dispose of the firearm before expiry. If he does not, he will be guilty of an offense. He knows what is expected of him before expiry of the license and is provided with legislative means to fulfill that expectation. The judgment is clear. If the gun holder does not renew the license, or the gun owner must apply in time to renew the license. If the gun holder does not, they must dispose of the firearm. That's the consequence. Now, are you saying we must in addition say that where the license has expired, the gun owner may reapply for a license in respect of that same firearm, which Justice Froneman said must be disposed or surrendered?
Justice, we cannot read paragraph 19 of that judgment in isolation. If you read paragraphs 20 and 21, it specifically deals with, but SA Hunters, going further, is also wrong in its contention that there are no lawful means of disposal after termination of the license. I can see no legal obstacle to handing over the firearm to the police after termination. The fear that the gun owner may be liable for prosecution if he takes steps to hand over the unlicensed firearm to the police is overstated. If that is the intention, it is difficult to imagine how it can be said that the gun owner can be guilty of an unlawful possession of the firearm. Our constitution will not countenance the strictest of the strict liability. And then in paragraph 21, he says, but then the complaint is that the police will or must destroy the firearm. It is submitted that the police have no legal competence to hold it in safe custody until the gun owner applies for and obtains another license. So that remains to the same firearm. And he then remarks, again, that what has this to do with irrationality? So he doesn't find on that basis. He says it's not irrational. It may infringe other rights that the gun owner may have, like section 25, protection of property, but that is a part of a different inquiry. So he never said, and he never made a finding, if one reads the 3 paragraphs, that you will not be entitled to reapply. What he does say is that sections 24 and 28 are not irrational. It simply means you may not possess the firearm, but that doesn't take away any other rights.
And the judge went on to deal with section 25 and whether the destruction of the property was constituted arbitrary deprivation. And the court held that it did not, because there was a compensation regime contained in the Act for surrendered firearms, on the basis that once the license expires, the firearm is surrendered to the state, and then it is destroyed after the appeal process provided for. The argument on behalf of the gun owners in that case was that would constitute arbitrary deprivation of property if their property was destroyed. And that argument was rejected on the basis that there is a compensation regime in place for surrendered firearms.
Justice, if we look at what had been said in paragraph 21, it's pertinently said that section 25 is not before that court. It was never before the court in the SA Hunter's decision. That's section 21. If we then turn the to paragraph that was paragraphs 29 and 50, where you refer to now, it simply says that there's a compensation regime that had not been investigated at all. If one goes and looks at section 134, 135, 136, 137, and the regulations issued in terms thereof.
Ayman, I think we're speaking at cross purposes. I am referring you to this court's judgment in SA Hunters.
Yes, Justice.
Yes.
Yes, and I'm responding there to Justice in paragraphs 29 to paragraphs 32 of that judgment. It deals with deprivation of property. And there a remark is made, and I would submit in the circumstances of that case and on the disputes before that court, it must have been made obiter for the simple reason there is merit in the minister's argument that if there is any deprivation of property, it occurs in sections that criminalize unlawful possession, and those laying down the time limits for the licenses. There is no constitutional challenge directed at these provisions. The impugned sections 24 and 28 merely give the effect to those provisions and do not independently amount to any new deprivation of property. But even if they do, the deprivation is not arbitrary. There is a compensation regime, and he refers to section 33, which is paragraphs or sections 134, footnote 33, 134 to 137. And he says the constitutional validity of regulation 94.1 is not before us. The contentions.
If I can try repeat, if I can try get to the nub of my question again, Mr. Snyman. In SA Hunters, the court held that upon expiry of a license, a gun holder must get rid of the gun. And in getting rid of the gun, there was no deprivation of property because the gun owner can claim compensation.
There is a specific judgment of the Supreme Court of Appeal that says there is no compensation except if it is utilized, that firearm is utilized by the state thereafter. That is the Justice Alliance matter, which we have referred to in one of the submissions of the Army Key. So this—
Mr. Snyman?
Yes, Madam.
I don't need to remind you that this court is the highest court. And this court would be bound by the decision in SA Hunters unless that decision is wrong.
Justice?
If this court has held in SA Hunters that there is a compensation regime, what would it matter? Or how far would it get us to say that the SCA has held differently?
Justice, in the compensation regime referred to, that court in SA Hunters did not investigate any of the compensation regime referred to in those sections. It simply says when, if it is forfeited, you are compensated. That's what the section says, 136, which we've referred to earlier. So there is a compensation regime in specific circumstances, but the compensation regime does not address all of these. So to simply say in passing, if I submit, sections or paragraphs 29 to 32 was not a finding after properly investigating whether there is a compensation regime. The argument was made to say, but if I have to hand it in, I'm not going to be compensated. That issue in terms of section 25 and an arbitrary deprivation was not pertinently before court. The court says that in paragraph 21 itself. So if we get to paragraph 29 to 32 to say, but it's not arbitrary because there's a compensation regime, we have to look at that compensation regime whether it compensates you in fact. And this court did not, in the SA Hunters matter, deal with that. It just in passing says there is a compensation regime. And on those basis,
on another matter, Mr. Snyman, is the decision of the Supreme Court of Appeal not inconsistent with the very purpose of the Act, which is to prevent the proliferation of illegally possessed firearms and to encourage people to apply to renew their licenses in time and to punish those who have not done so?
Justice, the punishment is not meted out by no longer being the owner thereof. The punishment is that either you can be charged because you're in illegal possession.
Please can you answer my question, Mr. Snyman?
I'm trying to answer it, Justice. If you can repeat the question.
Is the decision of the Supreme Court of Appeal not inconsistent with the purpose of the Act? And I've set out what the purpose of the Act is.
Justice, it is not. For the simple reason, the purpose of the Act, and you've read the purpose of the Act, it is quite clear to stop illegal possession. Now, the fact that I apply for a license doesn't mean I illegally possess that firearm. It doesn't even say that or deal with my previous illegal possession. It doesn't even say that that previous illegal possession is accepted to be correct. All we are saying is that I may apply, and the police may then deal with it as they deem fit. If they then say, but I am not entitled because I have not previously, I've not explained fully why my license was allowed to run out, and therefore explain my illegal possession, they can clearly charge me. And that is a criminal offense for which you can get 15 years imprisonment. But in the circumstances to say, I have no right to then simply apply, and I may not possess in the meantime, that is actually contrary to the Act. Because what I do is I give my firearm to the police, they then process it to be destroyed, and I can go and buy a new firearm. It means that there's more firearms in circulation, which is contrary to the Act itself. The Act says they want to stop the proliferation of firearms. In general, not only illegal firearms, but the more firearms there is, the bigger the risk to the population.
I must confess, it might be on my side, Mr. Snyman, but the logic of that argument escapes me. Because if you have a firearm in respect of which the license is expired, it is surrendered and destroyed, and then you buy another firearm and apply for a new license, I don't see how the circulation of firearms would increase, but we can leave that for now. My last question, Mr. Snyman, is, are the issues that are raised in this matter different from those issues that were before the SCA in gun owners?
Yes, it is.
And if they are different, in what way would you say they are different?
In Gun Owners Association, there was an interdict matter that was applicable, which is not here. The simple issue that may relate to this matter is a renewal. And what they asked for effectively in the Gun Owners Association matter, which was before the court in last year, was simply that they be allowed to renew even though it's lapsed. And the court said, you cannot do so. That's logical. It is lapsed. I cannot renew something that's no longer in existence. And that's not what our point is. Our point is it's no longer in existence, but it doesn't stop me from applying for a new license for the very same firearm. The firearm doesn't all of a sudden become tainted. I simply may not possess the firearm. My ownership doesn't get stripped away from me. The Act says it doesn't get taken away. It remains my owner. I'm the owner thereof till it is destroyed. Now, what is the purpose then of section 149 to ask a person who might have some interest in it to give his view on the firearm that is to be destroyed? If it's to be destroyed, there's no purpose of asking him even, or any process to be followed. He must be asked because they have a right.
Chief Justice.
Thank you, Justice Deron. Justice Pillay.
On the question of costs, Mr. Snyman, you got costs on an attorney-client scale in the Supreme Court of Appeal, but your heads asked for no special order for costs in this court. Is that still your position then?
Our position is set out. We don't seek special cost order at this stage. As a matter of fact, some of the costs went against us in the Supreme Court of Appeal because we had a very late stage or not change track. We limited our disputes to a very large extent, and they said we could have done that earlier. We're not seeking a special costs order in the circumstances. And if I recall correctly, I didn't even ask for a special costs order in the Court A Quo in the Gauteng division at all. It was asked in the papers. We didn't persist.
ACJ, may I, if my sister's finished?
Yes.
Just before I ask a question, just something that bothers me, Mr. Snyman. It seems to me now that where we are is that the applicant's position here in this case is that there's nothing precluding you in law from, as they read the act, from applying for a license, provided you surrender the firearm. In other words, you're not in possession of it, because that would be unlawful. But on the fact you've surrendered them long even before the SCA case, so it seems to me prima facie there's no justiciable issue before the court, is there? No longer, anyway.
Justice, the principle is still applicable.
Well, we don't decide matters on principle. Is there a justiciable issue between the parties? Is there a live justiciable issue left?
Justice,
it does bother me because the case has taken a sudden, unexpected turn with the concession on the one side. It seems to me from the applicants and your recordal now that these firearms were handed in long ago, even before the SCA matter. Is there any justiciable live issue between the parties?
Justice
before Mr. Snyman responds, before you respond, Mr. Snyman, I want to say this because I was going to say it anyway, but Justice Majid's question links with what I wanted to say. You know, the workload of this court has increased a lot over the years. If the parties had adopted, or if the applicant had adopted immediately after the SCA judgment, the position it has adopted today, namely that the respondent may apply for licenses in respect of these firearms as long as it has surrendered them. And of course, as I understand the position, the respondent had surrendered them. There would have been no appeal, and we would not be sitting here. And we would not have to undertake the arduous task of writing a judgment because the matter would have been settled. So the question that Justice Majid puts to you is a question that was in my mind too, to say, you know what the applicant's position is now. We all know what the applicant's position is now. Is there a need to, and I'm talking for myself, I'm not talking for my colleagues. Is there a need to burden this court with having to do a judgment? Or can the parties settle the matter?
Acting Chief Justice, I would submit there's two answers to the questions. The one is that the application for leave to appeal, if that is the correct position proposed by Mr. Shapwane, should not succeed without dealing with it further on the appeal itself, because it might then become moot because of the attitude of the applicant. But if we look at section 167, and this is in part in answer to Mr. Justice Majid's question, Justice Majid asked whether it is still justiciable point. In terms of section 167 of the Constitution, this court may decide constitutional matters and any other matter if the Constitutional Court grants leave to appeal on the grounds that the matter raises an arguable point of law of general public importance. And I would submit, just having regard to the number of amici curiae that submitted documentation, it is a matter of public importance to get clarity on this issue. The result would be, though similar, if the court either dismisses the application for leave to appeal or writes a full judgment and says this is why we support the application for the appeal that was done in front of the Supreme Court of Appeal, but it is a matter of importance to a number of firearms holders, and that is quite borne out by the amici that had made submissions in this court. We say it is a matter that is arguable point of law of general public importance, and that's the only basis upon which this court may deal with it. Apart from that, we simply say if the leave isn't granted, it still leaves intact the judgment of the SCA, which we say in principle is not incorrect.
Justice Majid, I intervened. You may have had. You may have.
No, ACJ,
you are covered.
I'm very pleased that you actually did that. Well, Mr. Snyman, it just seems to me that another consideration is whether it's in the interest of justice to hear a matter where all you're asking the court for to say is there's no longer anything to decide as between us and the minister, us being Fidelity. All you need to tell us is academically, what is your advice for all the people out there who have similar problems? And that is not what the court is there for. So it seems to me it's not in the interest of justice. But let me ask this question. If I think you accept that there's no express provision in the Firearms Control Act which says where a license has lapsed and you have surrendered, that you may apply for a license in respect of those same firearms. You say there's a lacuna in the Act, right? Am I correct?
Justice.
But well, if we are with you there and we find for you on that point, on the assumption there is still something to be decided, but on that assumption, if we decide in your favor on that point, could we not be accused that we are infringing the separation of powers doctrine in that we are making law, we are writing legislation because we are reading something into Section 6 or Section 20, absent a constitutional challenge to the Act?
Justice Majid, if I may just start out, in terms of Section 6, and it seems to be common cause between all the parties, and that I may, if I buy the first time a firearm, I may apply, or I'm entitled, I've got a right to apply in terms of Section 6, or then whatever section is linked with that, whether it's Section 20 or 13 or 14, I have a right to apply. There is no difference between that application and a second application in principle as to my right to apply. And that's what we are saying. The court does not even grant you, well, the Act explicitly a right to apply. That right emanates from somewhere else. And we say that is one of your privileges as an owner who wish to become the holder of the license. And if I may just refer to the, it is referred to as an entitlement of ownership. Part of your entitlement of ownership is in fact the right to possess or to apply for a possession. If I want to use a vehicle on a public road, I must have a valid driver's license. I may possess the vehicle, but I may not drive it on the public road validly or legally. Now, if I want to drive it on the public road, I must apply for a license. I have the right to apply. If my license lapsed, there's a provision in that Act for some administrative penalties, but after a while, I have to be relicensed as a person, or my vehicle must go through a test as well. So it's a similar situation here. My right to apply as an entitlement of ownership doesn't get taken away all of a sudden. I may not possess, and that's all that's being regulated.
Yes, thank you, Mr. Snyman. Thank you, ACJ.
Thank you, Justice Majid. It doesn't look like there are any further questions from colleagues. We are at 1:30. Mr. Snyman, it seems to me that the issues have been sufficiently canvassed, and you should not be wishing to say anything further.
I've got nothing to add, just Acting Chief Justice.
Yes. Okay. All right. Thank you. Let's hear Mr. Shakwana in reply if he has anything to say. Mr. Shakwana.
Thank you, Acting Chief Justice.
Yes.
I'll deal with about 2 or 3 issues in the reply.
I can't see you, Mr. Shakwane. I see the top of your head here. Now I can see you. Yeah. Okay.
Firstly, Acting Chief Justice, we disagree with the submission by our learned friend that there's no difference between first-time application and the second application. There is, because in the regime of Section 3, Section 24, and Section 28, you apply for the first license subject to it being renewed within 90 days prior to the date of termination. Now, if you fail, if you apply for the renewal within the 90 days before, then you can still have possession of the firearms. But should the time period terminate and you have not applied, your license terminates and you are not entitled to possess the firearms. You must surrender it. Now, you cannot therefore say the first time application and the second time application, there's no difference between. There is a difference. There are consequences when you didn't renew your license. But if you would choose to say, I do not apply, I do not renew, then there are consequences. Surrender the firearms. So, and secondly, my learned friend refers to the right to ownership. It's not an absolute right. It commented upon straight away in paragraph 1 of the SA Hunters decision. It's a privilege which must be regulated, and that's what this Firearm Act is doing. It's regulating that. So you may have bought the firearms, you are the owner, but it's regulated in terms of this. Why? Because this is a dangerous property, and Justice Theron commented on what the purpose and the intentions are, quite correctly so. So it is not the kind of scenario that my learned friend is painting. Then lastly, Acting Chief Justice, is the point relating to what is referred to as a concession by the applicants through me. The point that's been made there is this: it is not that the dispute has ended as my learned friend suggests. The instructions that I have are that there is not a surrender of the firearms by the respondent. I am informed that what transpired at the hearing before the SCA, there was just a say-so submission from the bar by my learned friend that there is a surrender. But when my junior, who then was the only counsel, took instructions, the instructions were that there is no surrender of the firearms. And that is even supported by what appears in the current opposing affidavit, Acting Chief Justice. One looks, for example, at page 451, paragraph 69, paragraph 71, and then there's also page 448, paragraph 57. There's quite a number of instances where these averments are made, which clearly show that the respondent persists with the position that it should continue to keep the firearms in its own possession. And when you read what their affidavit, which served before the SCA in volume 1, it's the same thing. They say they keep the firearms because the applicant will not have the capacity to store them. At page 33, paragraph 43, 44.
Well, Mr. Shagwane.
Yes.
The affidavits say what they say.
Yes.
Okay, that we know. But the position, as has been announced publicly, both by yourself and by Counsel for Fidelity, is the following. On your side, you have said the applicant has no problem with the respondent applying for new licenses in regard to these firearms, as long as it first surrenders them. And Mr. Sneyman has said publicly on behalf of the respondent has no issue with surrendering the firearms pending their application, if the applicant's authorities will consider their application. He has said that they have been surrendered. Your instructions are that they have not been surrendered, but your position, as I understand it, is the following, and you must tell me if I misunderstood it. If the respondent has already surrendered these firearms, it can lodge a new application or new applications, and the police authorities will consider that application or new applications. So that really whether they've been surrendered or not surrendered is a factual issue that can be sorted out by both parties. But the principle is, as far as you are concerned, your client's objection was the continued possession of the firearms by the respondent in circumstances where the licenses have expired. So if after today, the respondent satisfies your client that the firearms were surrendered, or if they were not surrendered, if it does surrender them, then they can lodge their application, and the application will be dealt with in due course, and the decision will be taken, and the firearms will not be destroyed pending the outcome of that application or those applications. That's the position that you have adopted, isn't it?
I think, Chief Justice, that is the submissions I made.
Yes.
That the submissions as I made them in that regard are not intended to detract from the applicant's case that the law as in paragraph 19 of the SA Hunters Act should take place. The respondent has no right to claim entitlement inconsistent or contradictory to that law.
Yeah.
If they reapply, if they want to apply, the regime was fully canvassed in at the time when I gave my main presentation to the court. Yes.
Yes. Yes.
My learned friend, the respondent is now even aware of section 136 and the others 139 and 149. It's got its options. Yes.
Yeah.
But the case is still live, that the applicants say the law in paragraph 19 of this court in the SA Hunters Act must apply.
Yeah. Yes, but that law, you say, doesn't prevent the respondent from applying, but you are saying it needs to do certain things before it applies.
Yes, I'm
Yeah,
submitting
that's all you are
that.
saying.
I'm submitting that that law does not stand in the way of the respondent's compliance with Section 136 and the other provisions that would entitle it to act.
Yeah. Okay. All right. Are those your submissions?
And I submit that the respondent, especially in view of the fact that all along it has been aware that the applicant's stance is one based on paragraph 19 of the decision of this act, and it is not arguing that that decision of the court is wrong. It must pay the costs, including the cost of 2 counsel were employed. As the court, please.
Okay, all right. Thank you, Mr. Shagwane. I didn't get any indication from colleagues, anybody still wanted to ask questions, put questions to you. Yes, thank you very much to both counsel for your submissions. Judgment is reserved, and the parties will be notified if there's something we want to convey to the parties. The court adjourns. The court adjourns.
As it pleases the court.
Today's proceedings have concluded. The host will now terminate the meeting.